because I know that several of my students will be watching on the video channel because they were assigned to attend this for class, but some of them have other classes. It gives me a great deal of pleasure to introduce to all of you Tsvetana Kamenova, whom I have known for many years, previously in her capacity as a law professor and dean of the Plovdiv University School of Law in Bulgaria. And she and I go back a long way, and I gather she goes back a long way with a couple of other professors around here, Catherine Klein and Leah Wortham, because we've all been involved with her in a variety of different teaching experiences over time. Professor Kamenova is currently the director of the Institute for Legal Studies at the Bulgarian Academy of Sciences. You've seen her short resume on the announcement for this program, and her relevant experience for this program today is that she served as a judge ad litem at the International Criminal Tribunal for the former Yugoslavia in The Hague until 26 February 2009. And she served in a couple of cases that were really very interesting. The Milutinovic case, which I think she's going to tell us a little bit about. And then she was elected to this position by the UN General Assembly in August 2005. For those of you who don't know what this International Criminal Tribunal is about, you will soon learn. But it certainly is one of the first two international criminal tribunals, the ICTY as it is referred to, and also the ICTR, which is the one in Rwanda. We now, of course, have an international criminal court, and so what Professor Kamenova is going to talk with us about is going to concern more generally the whole question of international criminal justice, the extent to which that is a relevant concern with respect to the international human rights regime that we have been living under since the end of World War II. She has a very long and very distinguished resume, and I'm not going to say any more about it, but I think you'll be interested to know that she is a candidate for the International Court of Justice at the present time, and so I think we're in the presence of someone whom we should all be very happy to welcome to our law school. Thank you very much for agreeing to be with us, and turn it over to you.
Thank you very much, Professor Simon. Good afternoon. First, I want to thank everybody in this room for coming. It's after 4 o'clock in the afternoon, and I know that after a long day, it's not always easy to come to listen to a talk at that time of the day. It's a great honor for me to see here some professors with I have worked earlier, so thank you, Professor Klein, for coming. Thank you, Lee. Thank you, Professor Simon, for inviting me. When Professor Simon invited me to give this talk back in November, she asked me to talk about my experience as a judge in the ICTY. And as Professor Simon mentioned, introducing me, I was elected to serve as an ad litem judge by the United Nations General Assembly in 2005, and I started working in The Hague in June 2006. I have immediately to say that I'm not a criminal lawyer, I'm an international lawyer. And perhaps you know that in the international courts and tribunals dealing with criminal law, half of the judges are international lawyers and half of the judges are criminal lawyers. Of course, I was flattered by the invitation of Professor Simon, but I think that the International Criminal Tribunal for former Yugoslavia, though still functioning, is already a part of the history of the international judicial system. This is why I chose to talk on something not connected with the history, but on problems that the international judicial system is facing today and will face in the future. And this is the important topic of the proliferation of the international courts and tribunals. So, I'll divide my talk into two parts. In the first part, I'll share some thoughts on the functioning of the tribunal. In the second, I'll share my views regarding the theme of proliferation of international courts and tribunals. As you may know, ICTY was founded by the UN Security Council in 1993, and nowadays it's closing its work. It was dealing, and it is still dealing, with war crimes that took place during the conflicts in the Balkans in the 90s. The work of this tribunal changed the landscape of international humanitarian law. It has proved that efficient international justice is something that's possible. I personally feel very proud of being a part of the history of the international judicial system as a judge who served in ICTY. Until I joined the ICTY in 2006, my knowledge of the international justice system was the knowledge of an outsider. Having been a judge in an international court gives different information from inside, and I would like to share with you some of my experience. The tribunal was, as I mentioned, established by the UN Security Council in response to mass atrocities in Croatia and Bosnia at that time. Let me remind you, it was the beginning of the 90s. It is made up of three main branches: the chambers, the registry, the office of the prosecutor. It applies the rules of international humanitarian law. This means the Geneva Conventions and the additional protocols to the Geneva Conventions. The most significant number of cases heard at the tribunal have dealt with alleged crimes committed by Serbs and Bosnian Serbs. The tribunal has investigated and brought charges against persons of every ethnic background. The tribunal takes no side in the conflict. Evidence is the basis upon which the prosecution presents a case. I was often asked after the end of the trial Milutinovic used to be the president of Serbia in 1998 and in 1999. So when the trial was over, I was often asked, why did we decide to acquit the president of Serbia? The answer is very simple. The prosecution did not present sufficient evidence to prove his guilt for the atrocities in Kosovo. It did present evidence for the other 5 defendants. Well, excuse me, I just want to change my...
The lights are very bright, and I can understand why she wants to change her glasses, because it's difficult to see when we're being videoed.
Yes. The ICTY was established as an ad hoc court. In 2006, the Security Council adopted a completion strategy for a staggered and ordered closure of the tribunal. The tribunal has charged more than 160 persons. Those indicted by the ICTY include heads of state, prime ministers, army chiefs of staff, interior ministers, and many high and mid-level political, military, and police leaders from various parties to the Yugoslav conflict. The aim of the tribunal is to concentrate on the prosecution and trial of most senior leaders and to refer certain number of cases to national courts in former Yugoslavia. Since the establishment, the Tribunal has consistently and systematically developed international humanitarian law. The work of the Tribunal and the achievements of the Tribunal have inspired the creation of other international criminal courts, including the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, and the International Criminal Court. The Tribunal has proved that efficient and transparent international justice is viable. The Tribunal is a unique institution and a pioneer in international legal proceedings. The first truly international war crimes tribunal and the first tribunal established under Chapter 7 of the UN Charter as a measure to maintain international peace and security. The ICTY has made a number of lasting contributions to international justice. What are the most important contributions? First, the Tribunal has created a new system of procedural law combining elements of adversarial and inquisitorial legal traditions. Second, it has established the most modern court facilities in the world, the layout and technical equipment of which have been taken as a model in other modern courtrooms, such as the International Criminal Court and the Special Court for Sierra Leone. The Tribunal has established, developed, and maintained an effective victims and witnesses protection program. ICTY has established a unique legal aid system and contributed to the creation of a group of defense attorneys who are highly qualified to represent accused in war crimes proceedings. The Tribunal has created a judicial database of all its jurisprudence, providing access to a vast amount of jurisprudence in international procedural and criminal law. The Tribunal has made numerous contributions to issues of procedural law, some of which are in the areas of protective measures for witnesses, the confidentiality and disclosure of information relevant for the national security of states, guilty pleas of accused, and duress as a defense, among others. What is the basic difficulty for a judge coming from the continental legal system to an international tribunal like ICTY? I must say that the basic difficulty was the adversarial system. The adversarial system, which is well known to everyone present in this room, it's not known by lawyers coming from continental European countries. The first thing that struck me was the excellent work of the teams of legal officers at the tribunal, especially at the chambers. Legal officers are young lawyers, graduates usually of master programs in international criminal justice. The work they are doing is something one cannot notice from outside. It is work done behind the scenes. Most of the work seems to be done during the hearings, during the trial itself. I'll give an example. The judgment of the case Milutinovic and others is more than 1,400 pages. I was often asked, how could we, judges, with the help of our legal officers, finish this for less than 5 months? I mean, writing the judgment for less than 5 months. In June last year, the Security Council in the UN in New York discussed the report of the president of the ICTY, and the question why does it take so long to write a judgment was put forward by some of the members of the Security Council. Here I'll just note in brackets that the judges sitting on another famous trial asked for 1 year to finish writing of the judgment. And this was the reason for the heated discussion in the Security Council. Maybe you know that the international judicial bodies, including the ICTY and the International Criminal Court for Rwanda, are often accused of being very slow. And as we all know, slowness is not a guarantee for quality. So the answer to this question, how could we manage to finish a trial with 6 defendants for less than 3 years, for 2 years and 8 months to be more precise, is very simple. It's good organization, discipline, and some months, even judges, not only the legal staff, had to work 12 to 13 hours a day. The presiding judge of our bench was Lord Bonomi from the United Kingdom. Lord Bonomi had a strong feeling towards spending public money. After all, this is the money of everyone, every taxpayer in a country member of the United Nations. And international justice is something very, very expensive. Thinking only of the cost of the translations, the 4 languages used in the courtroom, the bringing of all the witnesses to The Hague, the enormous work done by the prosecution and the investigators. Lord Bonomi insisted on our starting to write the descriptive part of the judgment at a very early stage. We had 13 crime sites in our indictment, and after finishing with the evidence on a certain crime site, we started analyzing the evidence and describing it, and in such way preparing the drafts for the future judgment. At the final stage, we had our drafts ready, and we were dealing mainly with the problems of sentencing, not with evidence. Now I would like to say something about the different legal cultures in international criminal tribunals, and especially in ICTY. It is well known that there is no other area in the international justice system where different legal traditions are contrasting as in the international criminal justice system. Most national legal systems based on civil law tend to apply the inquisitorial system, while in common law countries the adversarial model is preferred. As the famous Italian professor Cassese notes, neither model can ever be found in its pure form anywhere, because in practice, historical circumstances, local traditions, and the influence of the other model have led to an adaptation of each system to take account of the requirements specific to each country. Thus, the models at issue must be taken to be some sort of abstract intellectual constructs similar to the ideal types. Describing how the two models work, Professor Cassese concludes, the gist of the adversarial model is that it's based on 2 primary considerations: to leave the establishment of judicial truth to a contest between parties, to be essentially settled by a group of laymen representing the defendant's peers, and B, to protect the rights of the accused as much as possible by laying down a set of strict procedural safeguards that act as the ultimate bulwark against a judiciary prone to abuses or a potentially tyrannic executive. The essence of the inquisitorial model lies, on the other hand, in the strong emphasis on public interest in prosecuting and punishing all those who offend against societal values enshrined in criminal rules. Consequently, public institutions, such as the prosecutors and the investigating judges, play a significant role in administering justice, whilst lesser emphasis is placed on the role and the rights of the accused. The debate on which system is more appropriate for international criminal trials started when the rules for the Nuremberg trial were in preparation. The American Justice Jackson considered, and one can to a large extent share his views, that the final upshot of the debate substantially amalgamated the major features of both systems. Although one may note it was leaning more to the common law system, but all in all, opting for the adversarial system was a felicitous move at the time, writes Professor Cassese. The two ad hoc tribunals established by the UN Security Council in 1993, this is the ICTY, and in 1994, the ICTR, also embodied the essentials of the adversarial system, probably because of, first, the intellectual and psychological appeal of the Nuremberg and Tokyo model, second, the prevailing influence among the draftsmen of persons with a common law background, and third, it was felt that the adversarial system better safeguarded the rights of the accused. The ICTY statute laid down the fundamental features of the adversarial system. It entrusted the prosecutor with the conduct of investigations and the submission of indictments. After the confirmation of the indictment by a review judge, trial proceedings could commence. The rules of procedure and evidence adopted by the judges were in practice fashioning further the system. Initially, the court was conceived as a sort of a referee who could become cognizant of the material supporting the indictment or of the evidence produced by the defense only after commencement of trial proceedings. The court was granted extensive powers in matters of evidence on the Nuremberg model, and it was empowered to order either party to produce additional evidence and call witnesses. These were significant ameliorations of the adversarial system, essentially derived from the inquisitorial model. In short, the court had extensive powers in order to be in control of the proceedings. The rules of procedure and evidence were changed significantly in the course of the functioning of the ICTY, and this helped the judges better to control and conduct proceedings. When drafting the ICC statute, the Rome Statute for the International Criminal Court, the draftsman opted for the adversarial model, but introduced some significant qualifications, thanks primarily to the strong diplomatic efforts of the French delegation. Over the years, there has been a gradual incorporation of significant features of the inquisitorial model into the procedural system of the ICTY and ICTR. The need to speed up proceedings had been the primary rationale for this gradual change. When the statute of the ICC was elaborated, these developments were taken into account, and the draftsman envisaged a larger role for the victims, expanded functions for the prosecutor, and a crucial role for the pretrial chamber, entrusted with the task of scrutinizing the activity of the prosecutor. The procedural scheme is still largely adversarial, but important features of the other model are accepted. Thanks to this, the system can meet the demands of international trials, namely fairness and expeditiousness. This mixed procedural model was reached thanks to the jurisprudence of the ICTY and ICTR. An extremely important issue in international criminal tribunals is understanding the notion of different legal cultures. From a sociological point of view, it may be understood as referring to first language, skills and tools, the so-called cultural equipment. Second, socioeconomic norms. And third, culture-specific convictions about justice. When preparing my talk for today, I was advised by a friend to think of using a joke. American students like jokes, he said. They do not like the atmosphere typical of the European law schools. A professor reading his own textbook in a classroom. I must say I could not think of any joke. How can we joke when speaking of most hilarious crimes on earth? Of killing of tens of thousands of people. So I must admit I could not think of a joke, but I remembered something that happened in real life, and it may sound as a joke to your ears. After being elected, Secretary General Ban Ki-moon came to visit The Hague, the capital of the international law as it's known, the seat of many courts and tribunals. And when coming to see the judges in our tribunal, he was very surprised to learn that judges work in shifts. A morning shift and an afternoon shift. He said, I cannot believe it. No one in the UN system works in shifts. Then the president, an Italian professor, Fausto Pocar, simply explained that we had only 2 courtrooms with booths for translation and enough space for the defendants and their defense lawyers. The refurbishment of each of these courtrooms was worth several $1 million, so we had no choice but to work in shifts. And this is not a joke, it was reality. At this point, I'll end the first part of my today's talk, and I'll pass to my topic. Why is the topic of proliferation of international courts and tribunals attracting so much attention nowadays? In many articles published on this topic, one can read that the enormous expansion of international judiciary is the single most important development in the post-Cold War age. If during the Cold War age there were only 6 international judicial bodies, after the 90s and the beginning of the 21st century, we have already 12 new judicial bodies. As a matter of fact, some lawyers say that thanks to the end of the Cold War, it was possible to create the 2 ad hoc tribunals for former Yugoslavia and for Rwanda. The 5 countries, permanent members of the Security Council, could not be unanimous before 1989. It is considered that the traditional reluctance of states to submit themselves to judicial and quasi-judicial dispute settlement mechanisms has gradually eroded. And this is due to the following main reasons. First, there is an increased density of international norms which require sophisticated dispute settlement institutions. Second, there is a greater commitment to the rule of law in international relations. Third, the end of the Cold War has seen an easing of international tensions which had hampered the growth of international adjudicative procedures, and fourth, the positive experience of some international courts and tribunals has inspired the creation of more adjudicative bodies. And the only existing judicial body after World War II, the International Court of Justice, was unsuitable for the resolution of all types of disputes. Today we witness also a constantly changing docket of the International Court of Justice. Besides this, the quantitative change has been coupled with the remarkable expansion of the nature and competence of international judicial bodies. The proliferation of international judicial bodies of regional scope introduces a further element of diversity, for regional courts are much more influenced by local legal systems and practices than bodies with universal scope. This development, as I mentioned, is quite recent. Besides, a whole new genus has been reinvented: international criminal jurisdictions. And something more important, today we, professors teaching law, understand that international judicial law and organization should be studied as a discipline in its own right. Speaking about the proliferation of international courts and tribunals, I would like first to make some terminological notes. When we speak of international courts and tribunals, we do not always have similar understanding of these notions. This is why we need to define the notion international courts and the notion international tribunals. These terms very often refer to the same object. Depending on the legal culture and the legal system a lawyer comes from, he or she would understand differently the notions. For instance, in my legal culture, the name tribunal is usually connected with military tribunals, maybe starting with the Nuremberg or Tokyo tribunals. In legal writings of international lawyers, the term tribunal is usually associated with ad hoc tribunals like ICTY and ICTR. So where can we classify the International Tribunal for the Law of the Sea in Hamburg, Germany, which is neither military nor ad hoc tribunal? It is a permanent court created by the UN Convention on the Law of the Sea, adopted in 1982. Today, scholars refer to this convention as the Constitution of the Law of the Sea. Some authors are inclined to accept that while the term international courts designates only permanent judicial bodies, international tribunals, as I mentioned, should be used to indicate ad hoc institutions. Here I can give another example, the example with the Special Court for Lebanon, but I'll come to this a little bit later. The notion international judicial body is more acceptable to European scholars. At the end of the last decade, scholars from Europe and from New York University joined efforts working on a project called International Courts and Tribunals. They agreed that in order to classify an international jurisdiction as an international judicial body, it has to meet, according to Professor Tomschat, it has to meet 5 basic criteria. First, it must be permanent. Its existence must be independent from a given case. This criteria removes not only ad hoc arbitral tribunals, but also institutions like the International Court of Arbitration or the Organization for Security and Cooperation in Europe Court on Conciliation and Arbitration, which simply provide a stable institutional framework and provide a roster for ad hoc arbitration or conciliation. Second, it must be established by an international legal instrument. Some are established by a treaty, others by legal acts deriving their force from a treaty. Third, in deciding the cases submitted to them, they must resort to international law. Fourth, they must decide their cases on the basis of rules of procedure which pre-exist the case and usually cannot be modified by the parties. And as I mentioned, this was not the case with ICTY and ICTR. The rules of procedure and evidence were created by the judges and they were modified. And finally, the outcome of the process must be legally binding. Here I'll ask the question, where do we classify the consultative opinions which are not legally binding? The Italian professor Romero, who was leading this project, adds to this list 2 additional tests. For an international judicial body to be classified as such, it must be composed of judges who have not been chosen before a case is submitted. And second, an international judicial body must decide disputes between 2 or more entities, of which at least one is a sovereign state or an international organization. What is the merit of all these tests? They have the merit of restricting the list of international judicial bodies to a rather sizable and homogeneous corpus. The existing institutions that currently fit all the requirements enumerated are the ICJ, which is also called the World Court, the International Tribunal for the Law of the Sea, established by the Law of the Sea Convention from 1982, the European Court of Human Rights, established by the European Convention on Human Rights and Fundamental Freedoms from 1950, the Inter-American Court of Human Rights, established by the American Convention on Human Rights, the Court of Justice of the European Communities, together with its Court of First Instance, established by the treaty establishing the European Coal and Steel Community, the second one established by the decision of the Council of Ministers of the European Communities, then the Central American Court of Justice, established by the Protocol of Tegucigalpa, Court of Justice of the Andean Community, Court of Justice of the European Free Trade Association, Court of Justice of the Benelux Economic Union, Court of Justice of the Common Market for Eastern and Southern Africa, Court of Justice of the Arab Maghreb Union, Judicial Board of the Organization of Arab Petroleum Exporting Countries, etc. I think that the development during the last years rendered invalid the above-mentioned criteria. And I'll give some examples. The Special Court for Lebanon was established pursuant to the Security Council resolution from 2006, which resulted in an agreement between the UN and the Republic of Lebanon on the establishment of a tribunal of international character. It is mandated to prosecute persons responsible for the killing of Rafik Hariri, former Prime Minister of Lebanon, and some other persons, and for additional attacks during a certain period of time between October and December 2005. The Special Court for Lebanon started functioning on March 1st, 2009. It has to apply Lebanese law, not international law. So where is the criteria? Applying international law should be the international judicial bodies. I think this criteria is invalid. Also, this Special Court for Lebanon has half of its judges from Lebanon and the other half international judges who are selected by the General Secretary of the United Nations. Similar are the rules about another hybrid court, and this is the Special Tribunal, or as they call this Special Tribunal, Extraordinary Chambers in the Courts of Cambodia. The creation of the International Criminal Court, with 114 countries members today, was made possible to a great extent thanks to the development of the jurisprudence and the successful work of, as I mentioned, ICTY and ICTR. The International Criminal Court has special relations with the United Nations. It's not a UN body. And the adoption of the Rome Statute in 1998 opens a new era in international judicial bodies history. I think everyone in this room knows that the USA, Russia, China, India, and other countries are not parties to the Rome Statute, and they are not members of the ICC. Not all judicial bodies are, of course, eternal. The day the treaty established them, or the treaty that established the organization establishing them, stops functioning, the judicial bodies also stop functioning. When we make the inventory of international courts and tribunals, we should not forget the many international administrative tribunals that are in existence today. They are established to enable employees of intergovernmental international organizations to sue their employers, which they could not do in national courts because these organizations are immune, as a general rule, from suit in domestic courts. They have very interesting jurisprudence. Among them are the International Labour Organization Administrative Tribunal, the administrative tribunals of the specialized agencies of the UN, like World Bank, the International Monetary Fund. An own tribunal has the Asian Development Bank, the Organization of American States, and many other institutions. Another big group of tribunals are the various types of international arbitral tribunals. The law they apply is often not public international law, but national law, private international law, or international commercial law. A A different category of arbitral mechanisms are international arbitral institutions that provide dispute settlement facilities to states and private persons to resolve disputes between them. The modern prototype of such institution is the International Center for Settlement of Investment Disputes between states and nationals of other states. It is a World Bank institution, and these institutions apply both norms of public international law, private international law, as I mentioned, and their practice is a confirmation of the thesis that the traditional dividing line between public and private international law is gradually becoming less relevant and less pronounced nowadays. In concluding, 10 years ago, Professor Burgenthal, Thomas Burgenthal, who used to be the American judge in ICJ until last year, published an article in Leiden Journal of International Law. The title was Proliferation of International Courts and Tribunals. Is it good or bad? I would put the question in a different way. I would ask, is it inevitable? And my answer would be in the affirmative. Yes, it is inevitable. As long as the international community needs them, they will be created. Another important question connected with the proliferation of international courts and tribunals is, will there be some kind of hierarchy between international courts and tribunals in the future? I don't believe so. Thank you very much for your attention.